Papa's going to explain everything to you. We're going to probably move some things around and see. The people participating. Mario, Blasio, Blasio on his left, this Curtis Clark, who took his place, Leo Mulero, Geronimo Nieves, Anthony Papa, and James Seelandt. And once again, we give our sincere thanks to the Supreme Court, New York State Supreme Court judges who have been here helping us, Judges Torres, Judge Davidowitz, and Judge Mason. And also thank the Chief Judge of the Bronx, Burton Roberts, who's also on our advisory committee, for allowing his fellow judges the morning and part of the afternoon to come in here. And Ralph Popkin, our advisor, is going to explain to you a little bit about the issue, how Moot Court works, and then we're going to get started in their presentation.
Thank you, Dr. Wall. First of all, may I say that the Moot Court in a paralegal setting is extremely unusual. It is usually a law school setting, or at least a senior in a four-year college. These young men that will be presenting to you today have done a mammoth amount of work on a full-blown legal issue which has probably not been decided in the state. This is what is known as a case of first impression. In other words, a case which, on these facts, has, as far as we know, not been decided in the state. So what you are seeing, and the arguments that will be presented to you, are the arguments that will be brought before the Appellate Division First Department for this case to be argued upon an actual factual situation which was presented to our panelists. Before getting to this point, where they will be arguing, as they will be momentarily, and I have been told to keep it to within 3 minutes, my talk with you. They presented, and each side was served with, as the judges have received also, appellate briefs, which I would say would qualify magnificently in any appellate court in the state and nation. And I think our distinguished jurists will acknowledge that when they have their opportunity to speak to you later. I would say to you that they have done on their own, and I stress this. I presented the question before them, which I'll go over briefly with you, and then met with them along a timetable each Wednesday. And by the way, I would be remiss if I did not thank, although I'm not sure that they're aware that thanks are due them, the Legal Aid Society, which did without me every Wednesday afternoon while I was taking care of this tour. But each Wednesday there was a timetable of what was expected to bring us up to today. The week after they got the set of facts, I told them I wanted a list of cases and I wanted them to be prepared to discuss what those cases were all about and why they applied to the set of facts. And from that point on, they developed the arguments, they developed the work which will finally be expounded to you in their ultimate moment of triumph. It is also my moment of extreme pride. This, by the way, is my first semester teaching at BCC. And I've developed an extreme pride for these young men and the work that they have done. Now, just very briefly as to the facts of what this is all about. A defendant is arrested at his home the day after he has robbed somebody. He is arrested pursuant to an arrest warrant. In the robbery, he was involved with someone else acting in concert. may be lurking about and may be armed in the home. And so they do what they call a protective sweep of the home in a search for this other person and his arms. They, in the course of that protective sweep, in quotes, find certain materials which are used in evidence against the one apprehended person in his trial. That is the question largely before you as to whether such a search is protected under the Fourth Amendment, and more particularly, recognizing that we have in New York State a state constitution which gives at least the same rights as the Federal Bill of Rights, and in the interpretation of the courts, perhaps some better protected rights. So we are arguing in the Appellate Division, First Department, and our learned justices have been elevated for this occasion to sit as acting justices in the Appellate Division, First Department. They will be evaluating the presenters and the teams on the basis of the briefs which have already been served upon them, and upon the delivery, the quality of their oral arguments, as well as the written briefs, the independence of their recitation, the clarity of their presentation, as well as public speaking qualities such as the proper use of the podium, eye contact, posture, and gestures. They will render a verdict, a decision, should be an appellate decision, which will not necessarily be as to their thinking as to the particular case, but as to the quality of the arguments and the quality of the presentation along the criteria that I have indicated. At this time, speaking for the appellants, speaking for the appellants will be the law firm of Leo Mulero, Anthony Tappan, and Geronimo Nieves. Speaking for the Honorable Justices for 10 minutes with 2-minute rebuttal. Thank you.
My case is rested now. And my case for me.
Hey, Doug. I'm just getting set. Yeah, I'm getting ready to sit down, man. Ain't no way in the world I'm gonna stand up for this shit.
Your Honors, my colleagues and lawyers and advocates, distinguished counsels, good morning. May it please the court. My name is Leo Mulero, counsel for appellate Alex Gomez on this appeal, with co-counsels Anthony Papa and Geronimo Nieves. This court has been provided with appellate's brief and supplemental memorandum, and I trust that you are essentially familiar with the facts of this case, as with our legal decision. Therefore, I will attempt to concentrate my argument on the central issue of this matter. What we have here is a lawful arrest of appellate on the charge of robbery, based on the sole allegations of one Anna Soto, complainant witness hearing. This arrest was executed at appellate's residence 2 days after the alleged robbery, and 1 day after obtaining an arrest warrant naming only defendant, Alex Gomez. During the course of this arrest, and upon securing and handcuffing appellate, the police then decided to search a closet and dresser drawer, where incriminating evidence was subsequently discovered and seized. This warrantless search was predicated and accepted by the court below on the good faith belief that someone else was armed and concealed in appellate's residence at some point after appellate's arrest. However, this belief was not based on any specific or articulable facts to support the precept that the officers feared for their lives at the arrest scene. The issue here is whether Appellate's constitutional rights were violated by the warrantless search of his home, incident to arrest, where no exigent circumstances existed to justify a protective suite search for another person, and whether the evidence seized, which was not in plain view when discovered, should be suppressed as proof of an illegal search. We contend that it should. Our position is premised on the state constitutional standard of exigent circumstances, as opposed to the good faith exception often used under the more flexible federal constitution. We submit that at the lower court adopted the mandated standard of exigent circumstances based upon specific and articulable facts, as it should have, the evidence in this case would not have been admitted at trial against Appellate.
Mr. Mulero.
Yes, sir.
I hesitate to interrupt, but I have a question. As I understand it, the police, when they were inside the apartment, noticed the defendant, or the appellant, reach towards a drawer in a very sudden, what they perceived to be aggressive fashion. What, in your judgment, should the police have done once they saw the defendant do that?
Well, sir, as I understood the facts, the hearing court below never stated any facts of that nature, which would have eased me of this.
Well, wasn't there something in these briefs about the fact that someone reached for a dresser drawer?
If you would refer to my brief, I never mentioned anything of that nature.
Well, that's contained, I think, in the respondent's brief, isn't it?
I believe so.
All right, so if I were to assume that the respondent's version of the facts was correct, how would you answer that?
Okay, if the defendant had made an attempt to reach towards the drawer, the police conduct at that point, in my opinion, would be to secure the defendant, handcuff him, and remove him from the area, and then obtain a warrant for the search of that particular area.